All right. T minus 5, 4, 3, 2, 1. All right, take off. Good morning. My name is Julie Johnson. I'd like to welcome you to our ethics training for 2019. I want to thank you for being here. As I said, I'm Julie Johnson. I'm a staff attorney at the Legislative Services Division, and I'm here today with Jarrett Coles and Jameson Walker, two other able attorneys from our office, to talk about ethics. Today we're going to highlight why ethics laws are important. We're going to provide some background on how Montana's ethics laws were developed and provide an overview of Title II, Chapter 2 of Montana Code Annotated. That's where our Code of Ethics is codified. And finally, we will be discussing the process for addressing ethics issues in the legislature. Specifically, Jarrett will address gifts, the use of state resources, and the holding of dual offices. Jameson will address conflicts of interest, voting, contracts and claims, and nepotism. And I get to discuss bribery, official misconduct, and legislative immunity. And finally, Jarrett will wrap up with addressing ethics issues in the legislature. So we encourage you to ask questions, interact. If you do have a question, raise your hand and we'll get you pegged here on the microphone so we can all hear your question. I also want to make sure you all have the handouts. I believe there are 5 you should have received as you entered the House chambers. If you don't have it, please just raise your hand and someone will bring you a packet. Okay? 2, 3. All right. Thank you. All right, so why are we talking about the ethics? I'm sure some of you are saying to yourself, hey, I'm an ethical person. I do know the difference between right and wrong and what's good and bad. I don't need these people, especially these lawyers up here, telling me what's ethical and what's not. Well, if that's you, I want to assure you that what we are talking about today isn't necessarily how your moral and ethical compass should guide your decision-making process here in the legislature. But what we are talking about really is a minimum baseline of conduct that you have to follow as legislators to comply with Montana's ethics laws. So during your time here, as many of you know or will come to know, you will be faced with an absolute minefield of choices and decisions. You will have to decide whether to vote for or vote against particular issues, whether to compromise on certain things, how to interact with other legislators, staff, lobbyists, and members of the public, and you will be asked to attend many events and show your support for different causes. So what we want to impart upon you is that you are no longer a citizen of the state or a member of the public. You're no longer just that. When you were elected and sworn in as a legislator on this first day of session, you became a public official with public trust and responsibilities. As it states in the Code of Ethics, the holding of public office or employment is a public trust created by the confidence that the electorate reposes in the integrity of public officers, legislators, and public employees. So following the ethics law is important for many reasons, but one of the most important reasons is because it fosters public trust in our public institutions, and it really is a cornerstone of our democracy. So let's talk about the background. I'm sure many of you have read up on it. It's pretty entertaining. Montana has a long and storied history when it comes to governmental ethics and public corruptions. So maybe some of you have heard of the quote, "I never bought a man who wasn't for sale." That can be attributed to our own William Andrews Clark, who was notorious for having bribed several legislators to appoint him to the newly created Senate seat. Clark won, or what many would say, bought the seat by evidently spending several thousands of dollars to bribe legislators. So let's jump to 1972 and our new Constitution. It requires that the legislators adopt a code of ethics that specifically prohibits conflicts between public duty and private interest for legislators, as well as for state and local officers and employees. At its core, the purpose of the Code of Ethics is to prohibit conflicts between public duty and private interest. So in general, the Code of Ethics recognizes that some actions are conflicts regardless of the facts, while other actions may or may not be conflicts depending on the circumstances of each situation. So most of the time, you will need to analyze all of the facts of a given situation and determine whether an ethical issue exists. So at this time, you may want to pull out Title II, Chapter 2. This chapter is broken up into 3 parts. The first part is the Code of Ethics, and these are the provisions that establish the rules of conduct and ethical standards for legislators. It's also made up of Part 2, which deals with provisions related to contracts and claims, which Jameson will be addressing shortly, as well as Part 3 addresses nepotism. At this time, though, I will turn it over to Jarrett to talk about gifts, the use of state resources, and the holding of dual offices.
Thank you, Julie. Good to see everyone here today. It's a big crowd. Again, my name is Jarrett Coles with the Legislative Services Office. I think what I'm going to do is we're going to jump around a bit and maybe not go quite in the way the order of the agenda is. The first thing I'd like to do is discuss dual offices. And I don't know if anyone's ever heard the term issue spot, but my whole intent of going through this particular section is so if something ever comes up in the future, you can analyze the issue further. To become an expert in dual office is a tough thing. It's based on court rules and procedure, but basically there's a separation of powers doctrine, which we all know something about, and you have the executive branch, the judicial branch, and the legislative branch of government. There's a provision in our Constitution, however, that prohibits a legislator from holding a dual office, and it's actually in Article 5, Section 9 of the Montana Constitution. The provision is not in your packet, but it does say that no member of the legislature shall, during the term for which he shall have been elected, be appointed to any civil office under the state. So what does that mean, be appointed to? So this would be dealing with governor's appointments or any appointments. And no member of Congress or other person holding an office under the United States or this state shall be a member of the legislature during his continuance in office. So what does this mean? Basically, there are obviously some positions that have power. Could you be a governor and a member of the legislature at the same time? No, you could not. You'd have two branches of government tied up there. But there's some things that are not quite as clear. There's a lot of boards, there's a lot of entities that have power. And if that happens to be the case, you cannot be a legislator and a member of the board. So really what I'm trying to do with this section is if you ever have a situation where you're curious if offered a position, if that position violates the dual office rule, with the Legislative Services Legal Division Office, we do tests for people all the time. There's a Attorney General opinion that guides the process of whether or not something is a dual office, and then obviously the statutory provision and a court decision that's a famous court decision that we go through. And it is a complicated test. There's this court decision called State v. Barney versus Hawkins, and there's basically a 5-part test that you apply to determine whether someone is in an office of power. It has to be something that's created by the Constitution. It must be a delegation of the sovereign power. The powers must be conferred and the duties discharged must be defined by law. They must be performed independently without control, and it must have some permanency. So again, fairly detailed list of what pertains. I think the best thing is there's an Attorney General opinion out there that says these were civil offices and these were not civil offices, and I look at that often. If you happen to be a county high school trustee, you cannot be a legislator at the same time. That's been found to be a civil office. There was a Montana Relief Commission back during the Depression where the members of that commission determined whether to give relief to Montana citizens. Being a legislator on that commission was seen as a powerful position. You couldn't do that. There was a state conservation committee. You couldn't be a constitutional convention delegate and a legislator at the same time. Or a member of a local government study commission, so it gets down to local government. You couldn't be a mayor and be a legislator at the same time. You know, they're kind of basic concepts, but sometimes it gets really into the weeds of determining what a power a board has. These, however, are not civil offices. A university instructor, you can do that and be a legislator. An income tax auditor, a member of a joint water rights study commission, the state agency legal counsel, so if I wanted to run, I could, although I would not want to be in your guys' position, but if I wanted to, apparently I could. And a precinct committee person. That's all I'm going to give you on dual office. Again, I want you just to be able to issue spot. If there's questions on it, we can come to you. I tell you, it is a real fact and circumstances thing, though. Usually I have to look at what it is that you do and analyze it. So I'm not seeing any hands go up, so I'm going to move on to gifts. So if you can see this bag, it says on here somewhere, this is a gift for you. So anyone, if I was to just meet you on the street and give you this gift, would that be a bad thing? Anyone know if I could give you, would you take this? Anyone? Anyone? Not seeing anyone. So I guess the answer to that question is what's in the bag? So I was looking around my office and I found a bag. There's some instant lunch noodles in there, and that's all I had. Nothing else in the bag. So anyone think it would be okay to take that if I was to give it to you? I'm seeing a lot of shaking heads, yes. You could. We'll go through why. Now, I don't have $50 because I have kids, but if I was to reach in my wallet and pull $50 out and pop it in here, would that be okay for you to take if I was to give it to you? I'm seeing a lot of shaking heads. No, that's good. So now we're going to go through why you got those answers correct. What I'm going to go through are two different things. You received a handout that is, it says ethics quiz on it, test your knowledge. The first thing I went over was dual offices. In hypothetical situation one, you will see a dual office question. You can go through this on your free time, which you won't have. But if you do have free time, you can do that. And it will show you the test for dual offices. Hypothetical question 2 is also about dual offices. Hypothetical question number 3, which starts on page 4, deals with gifts. And there's actually some pretty good information that I'm going to use on this. So we're going to kind of go through the statute, and we're going to start with question number 4. So basically, this question starts out, and there's a professional lobbyist. You've worked with the lobbyist for a long time. He offered to buy you and members of your caucus lunch or dinner, it really doesn't matter, at the Capital Chicken Club, or CCC, because around here we really like to put, any abbreviation you can with any type of statute. So you're going to eat at the CCC. It's a quiet location to dine and discuss business, and several of your members agree to have lunch with the lobbyist. You're looking at the menu, and most of the meals are around $15. The lobbyist informs you that he wants to thank everyone for voting on House Bill 1000 by ordering the deluxe chicken dinner. So, woohoo. You look down, and it turns out that the deluxe chicken dinner also comes with a bottle of Dom Perignon. There's no price on this menu. You don't know what it costs, but you pull out your smartphone, and it turns out they're around a $150 meal that you'd have in front of you there. So do you let the lobbyist pay for the chicken dinner? Now, it's unfair because you can see the answers here, but we're going to just kind of go through a couple of them. But the favorite one is, no, definitely not, because the champagne was not made with Montana agricultural products, so you should definitely not let the lobbyist buy the chicken dinner for you. That's not the correct answer. Yes, because the cost of the food is approximately $15. It will take at least 3 days to consume the entire bottle of Dom Perignon, which in turn would lower the amount of the lobbyist spent on a per-day basis, and it would be fine. Probably not the best thing to do there as well. Yes, go ahead and do it as A, because the menu doesn't indicate the price of the deluxe chicken dinner, so it must be okay. Or the correct answer, B, no, it would be a violation of the Montana Code Annotated. Now, it's a little unfair to hit you with this question first because we didn't even go through the law on it. And that was partly by design, just to keep you awake. So the law provides that as a member of the legislature, you may not accept a gift of substantial value or a substantial economic gift tantamount to a gift. And since you're reviewing laws all the time, I'm going to show you where this provision is, because there's a definition section, and then there's also a section that deals with the gifts. So we have to know what a gift is. And to do that, you would have your handout that says Title II. This is Title II, and we're going to go to page number 2. It's just the second page in. And you'll see a bunch of definitions. The number 3 is gift of substantial value. So I'm going to kind of just use this as a reference point. But I did take and get the relevant points for this in the quiz handout on page 5, and you'll see exactly what the statute says in a little bit easier to understand way. But the term does not include a gift that is a value of $50. So if it's $50 or more, that would be bad. It means a gift with a value of $50 or more. So if it's $50 or more, it's a gift of substantial value. So really, $49.99 in this bag may be okay. That's when you get into your personal ethics of whether you should do that or not. But it's a $50 test, really. If it's 50 or more, then it's a gift of substantial value, and then that would be an impermissible benefit to receive. It does not include, however, certain things. There are exceptions. So you can see where the term gift is, and you can also see in your handout that I put those in about the middle of page 5. It would also be something that would improperly influence a reasonable person in that person's position to depart from the faithful and impartial duty of the person's duties, or if the person should know under the circumstances that the gift is primarily to reward the person for the official action taken. So in that hypothetical question, when the lobbyist said, "Thank you for voting this way on House Bill 1000, you should know that that would be reward you for the purpose of official action taken. So regardless of what the amount of the value of the dinner was, that would be a question where you ask yourself, should I really accept this or not, even if it was under the $50 limit? And that gets into more of your personal opinions on that. And then there are some exceptions. There are situations where you don't have to turn back a gift of substantial value. Let's assume you get a gift from someone and you just don't have the heart to tell them that you don't want it at that time. It's exactly a $50 gift, or it might be around $50. There's actually a way you can donate that gift to charity, and as long as you don't take an income tax deduction on that, you're okay. And I go through the exceptions on page 5. So if it's a gift that's not used, so you can't use the gift, and you return it to a charitable organization or the state and it's not claimed for tax purposes. The second exception is food and beverages that are consumed at a charitable, civic, or community event in which participation is related to the legislator's office or in which the legislator is in attendance in an official capacity. Educational material, there's a lot of members that do receive education. And if you receive a big trophy for being a member of the legislature and you really don't know if this thing's worth $50 or not, an award that's publicly presented, so if you get this big trophy in a room somewhere, you don't have to worry about that. It was given in a public environment. So that question really does get to the heart of what you need to look at. The term gift and the definitions is important to look at. And this is also defined in statute regarding not being able to accept gifts of substantial value. It's on page 3. It's on their rules. It's on 2-2-104, and it starts with number 1. And B, you cannot accept a gift of substantial value. So really, you got to start with the definition first to figure out what a gift of substantial value is, to know what they're talking about on this particular issue. So if there's no questions on gifts, I'm going to move on to use of state resources. Does anyone have any questions on gifts of substantial value? Seeing none. Okay, the last one I have until we turn it over to Jameson is use of state resources. And we do have a question in the packet on this. And again, you can go through these kind of on your own time. But I'll cover number 4 briefly. So this is on page 6 of your quiz handout. And the question is, there's an upcoming general election ballot that contains several initiatives, including one which you are highly supportive and want passed. The passage of this particular initiative will directly impact the constituents in your district in positive economic ways, and it's similar to legislation you've advocated for in the past. In response to an inquiry on what you can do with the campaign to help out with the passage, someone suggested that you send a letter to all your constituents urging them to vote yes on the initiative. This is a task that, obviously, given your extremely busy schedule, that you should delegate to Legislative Services Division and have them draft it up and mail it during the regular business hours at the State Capitol building. So the question posed to you is, may you utilize Legislative Division staff, equipment, materials, or other legislative resources to send the mass mailing to your constituents, urging them to vote yes on the initiative? And the correct answer, just to get to it, is no. You'll see that on the back. We go through the reasoning for that. It's based on a statute, which you'll have in your packet, and that's in 22121, sub 3 on the statutes that you have in front of you. That starts on page 6. But except as provided in subsection 3B, a public officer or public employee, which would include your Legislative Services Division staff, may not use public time, facilities, equipment, supplies, personnel, or funds to solicit support for or opposition to any political committee, nomination, or election of any person to public office or the passage of a ballot issue unless it is the use for authorized by law or properly incidental to other activity authorized by law. So you can't use your legislative staff for that. There are some exceptions for things like this. You are conducting business, obviously, when you're in the Capitol. You can use the telephone system. You can use the internet for conducting business, and I'm going to get you the joint rule of why you can do that. So while you can't utilize legislative services staff, which we're nonpartisan anyway, so we wouldn't get involved in that type of thing, but if you look at Joint Rule 10-70 of the joint rules, it said telephone calls and internet access, long-distance telephone calls made by a member while the legislature is in session or while the member is in travel status are considered official legislative business. So you do have a carve-out in your rules for being able to conduct some business on the phone system and on the internet system. So I probably went through more time than I should have on that. Is there any question on state resources? And we're going to mix it up so you guys can stay awake. We're going to turn it over to Jameson Walker.
All right, good morning, all. I don't promise you'll stay awake for me, this presentation. That was a contract I cannot keep. All right, so I'm going to be talking about conflicts of interest, voting, and nepotism. So I'll begin with conflicts of interest training. So typically with all these presentations, we're going to be giving you just a source, where to go, where to look, and where to begin. If you have any questions in the future, you'll have your packet here. You'll know where to look. But as always, feel free to stop by Legislative Services if you have any questions. All right, so the general rule with conflicts of interest. This pertains only to really legislators and the legislative process. So here's the general rule. Disclose, then participate. Disclosure is basically the main process to avoid the appearance of impropriety with conflicts of interest. So what is a conflict of interest? Well, conflicts of interest are primarily defined in 22112. You should all have that statute in your packet with you. There's also legislative rules for conflicts of interest. There's a joint rule that's 1060. Hopefully all of you have kept your rule books. There's new ones coming out, though. New ones coming out. Joint Rule 1060 governs conflicts of interest, and then there is a House rule, and that is 5200. We'll touch on that in a little bit. All right, so what's a conflict of interest? Conflict of interest arises from a personal or private interest that would directly give rise to an appearance of impropriety as to the legislator's influence, benefit, or detriment in regard to the legislative matter. If anything, the key phrase from this is that it's a private interest that would give an appearance of impropriety. All right, so let's go on. What is a private interest? The statute mentioned you have a private interest. Well, private interest may be various things. Some examples are an ownership interest in a business, a creditor interest in insolvent business, an employment or prospective employment for which negotiations have begun, an ownership interest in real property, a loan or other debtor interest, or a directorship or officership in a business. And these are kind of all outlined in your packet materials. But those are good examples of what a private interest may constitute as you members of the legislature. All right. So a conflict does not arise from legislation or legislative duties affecting the legislator's membership in a profession, occupation, or class unless the membership is so narrow that the vote will have a direct and distinctive personal impact on the legislator. Basically, the rules contemplate that you folks are going to be voting on all sorts of issues and a lot of things that may concern your life. So it's defining a conflict of interest a little bit more narrow, that it has to have a direct and distinctive personal impact on the legislator. Otherwise, it'd be hard to, I would imagine it'd be hard to vote on most anything as a legislator if it were broader than that. All right, in determining whether a conflict of interest exists, a legislator shall consider whether the conflict impedes the legislator's independence of judgment, the effect of the legislator's participation on public confidence in the integrity of the legislature. Again, that's getting at that impropriety, the appearance of impropriety theme. Whether the legislator's participation is likely to have any significant effect on the disposition of the matter, and whether a pecuniary interest is involved on whether a potential occupational, personal, or family benefit could arise from the legislator's participation. All right. So, how can a legislator determine if they have a conflict of interest or not? We're getting to the fun stuff. There's an informal process and a formal process for determining whether there's a conflict of interest. Typically, you see the informal process, but there is a formal process. All right, informally, a legislator can talk to the legislative leadership regarding the potential conflict prior to taking a vote. Remember earlier I said disclose, then participate. That's the key to get these out in the open before the vote. That's pretty much, if you know anything before that of this presentation, it's disclosed, then vote, but prior to a vote. Also, a legislator may also contact the code commissioner to determine if a conflict exists. Formally, a legislator may also request that the applicable ethics committee advise the legislator on whether the legislator have a conflict of interest. A legislator may briefly present the facts to the committee, and the committee shall advise the legislator as to whether the legislator should disclose the interest prior to voting on the issue. For those of you keeping track, that would be Montana Code Annotated 2-2, 112, and then subsection 2. So for all those code nerds out there, there's your site. All right, so we've been through the definition of conflict of interest and examples of interest that may cause a conflict of interest, and the formal and informal actions of a legislator that may be taken if a conflict of interest is suspected. So what should a legislator do if there is a conflict of interest? Well, so here's the nuts and bolts of it. A legislator has a legal responsibility to participate in all matters as required by the rules of the legislature. Under the House rules, a representative shall vote on all matters unless the legislator has disclosed a conflict of interest to the House. A legislator may, subject to legislative rule, vote on an issue on which the legislator has a conflict after disclosing the interest. That's in 22112 and House Rule 5020. Again, the operative phrase here is disclosure before taking a vote. The bottom line is that in the House, a representative is required to vote on all matters unless the representative has a conflict of interest. And even then, if the representative has a conflict of interest and they disclose it, they can vote on the matter. In the Senate, there's no specific rule to the Senate relating to conflicts of interest, so it appears they have to vote on all issues. So disclosure is the method there. I've got a quick hypothetical. You know what? We'll go through it and try to liven this up. All right, here's a hypothetical question. You're hearing a bill on second reading that would establish a self-help law center in each county of the state. The bill provides funding to hire a full-time attorney staff for each center. You are an attorney and very interested in applying for this position should the bill pass. Does a conflict of interest exist? We'll go yes or no. Anyone for yes? A few yeses and then no? All right. The answer is no. A conflict of interest likely does not exist from this one because it does not have a direct impact on the attorney. There could be a lot more other attorneys who are qualified for this job. It's not, it's not a shoo-in that the legislator attorney would get this job. But I'll turn it on its head. Same facts as before, but suppose that the bill requires each county attorney to hire an attorney who has resided and practiced in that county for the immediate 5 years. You know that you are the only attorney in your county who meets these requirements. Does a conflict of interest exist? Yeah, that's generally thought to be yes. There probably would be a conflict because you are, to your knowledge, the only person in that county who would qualify under that law. I'm not sure what county that might be, but it's possible, I suppose. All right, so that is conflicts of interest. Any questions? All right. And again, as always, feel free to stop by any of our offices. We can explain this stuff. All right, contracts. The ethical requirements for contracts is in 2-2-201. You all have that statute. Generally provides that members of the legislature may not be interested in any contract made by them in their official capacity or any body, agency, or board which they are members or employees if they are directly involved in the contract. So the general rule here is that if you're a legislator, you may not be interested in contracts. Kind of the main takeaway. All right, so subsection 2 of the statute 2-2-201 then provides some clarity as to how one may be interested in what the statute considers a contract. The statute then also defines what it means to be directly involved in that contract, so it breaks down the terms. All right, so 22201 provides what does not constitute a contract. So interestingly, the statute doesn't really provide what a contract is, but it says what a contract is not. It's kind of cutting out the exceptions. I see that as the purpose, to make it broad and then provide the exceptions therein. So the statute in subsection B, it says what a contract is not, and it's contract awarded on the basis of competitive procurement procedures conducted after the date of employment termination, merchandise sold to the highest bidder at public auctions, investments or deposits in financial institutions that are in the business of loaning or receiving money, and a contract with an interested party if, because of geographic restrictions, a local government could not otherwise reasonably afford itself of the subject of the contract. Again, this is kind of at some of the smaller counties out there. Probably not the county in my hypothetical question, but there is a geographic consideration there. You're the only person in that county who sells widgets or something like that. So that is an exception to the contract statute. All right. And so finally, for the purposes of legislators here, the statute defines what directly involved in. So remember that you have to have an interest in a contract and be directly involved in that contract. So what's directly involved? It means the person directly monitors a contract, extends or amends a contract, audits a contractor, is responsible for conducting the procurement or for evaluating proposals of vendor responsibility, or renders legal advice concerning the contract. So basically, just to think about that, it's you have a position of a deciding position in the contract. You have a position of influence in seeing that this contract get awarded. That's pretty much what the statute's getting at in that definition. All right, so finally, what happens if you're interested in the contract and are directly involved in the contract and the contract's made? Well, violations of the law may void the contract. Also, in some cases, the statutes provide for criminal penalties on that. All right, so I've got a hypothetical question for you. I think we got some time. Using a competitive bidding process, the state of Montana, through Legislative Council, will be considering proposals from vendors for a contract to create a new bill drafting system for the legislature. You currently serve as a member of the Montana House of Representatives and serve on the Legislative Council, which meets during the interim between legislative sessions and is responsible for reviewing proposals from vendors that seek to perform the services to create a new bill drafting system for the legislature and for making the final selection of a vendor. You are also a 51% owner of a closely held software development corporation, Lawmaker, which builds and creates bill drafting system software. Lawmaker's other shareholders want to submit the bid for contract. And actually, just going back a bit, just to make sure that the statute provides that you don't have an interest in a corporation if you have less than a 50% share in that corporation. I think I glossed over that earlier, but this fact pattern is getting at that. If you have an interest in a company, if it's below 50% or managing member of it, you're considered not to have an interest in that. All right, so that's a long question, but here's the question. If Lawmaker submits a bid and is likely to be awarded the contract based on being the lowest bidder, as a member of the Legislative Council, does disclosure of your personal interest in Lawmaker and you voting on the competitive bid procedures and on the subsequent contract, if it's awarded to Lawmaker, protect you from liability on Montana law? Well, it's kind of a long question, but the best answer is D, no, because neither disclosing that you have a personal interest or voting on the selection of Lawmaker or the subsequent contract puts you in compliance with Montana law. So the takeaway from this is when it comes to conflicts of interest, that's mostly a legislative function, and to which disclosure will cure something. However, in the awarding of contracts, disclosure is not, it's not like the cure-all for contracts or anything like that. So these laws are kind of, they're together, but they're separate. One is specific disclosure to the legislature, but contracts applies to all state government. So the answer is no, just because you disclose that you had this interest does not necessarily, absolve you from these laws. So, all right. Any questions? All right. Last thing, nepotism. I'll try to make this one quick. All right, final issue, nepotism. Everyone's heard that term. I'll begin with the operative statutes for that, so in case you ever need to go on Jeopardy or whatever. It's 2-2301, 2-2302, and then 2-2303 and 2-2304. All right, so what's nepotism? 2-2301, pretty simple definition. Nepotism is the bestowal of political patronage by reason of relationship rather than merit. All right, so that statute's written pretty broadly. Doesn't really get into the degrees of relationship. It just says it's the bestowal of political patronage by reason of relationship. All right, so now is 2-2302. That kind of refines it a little bit as it applies to Montana state government. All right, this statute generally relates to appointments or relatives to an office in Montana. It provides that it's unlawful for a person or member of any board, bureau, or commission or employee at the head of a department of the state or any political subdivision of the state to appoint to any position of trust or emolument any person related or connected by consanguinity within the fourth degree or by affinity within the second degree. That's a mouthful. All right, so we got some big words there: emolument, consanguinity, fourth degree, affinity, all this fun stuff. I think all of you have this here, the relationship chart. This may be the most important lesson from the nepotism lecture here. It describes what relationship in the fourth degree is. We'll see down there it's great-grandparent, great-aunt or uncle, first cousin, great-niece or nephew, and great-great-grandchild. Brushing up on this, I was surprised to find out that my brother is second-degree relative. I don't know, for some reason I thought that would be first. But anyway, take a look at this if you ever need. This is fairly useful. It's got a definition of nepotism in there and has some pretty useful information. All right, I'll wrap this up. So we went through consanguinity. So there's some, like the other statutes, there's some exceptions to the application of this section. Basically, in Montana, it's kind of like, what's it called, the world's, smallest town, state, or I don't know, I'm messing up that term, but there's some exceptions just because in some counties it's too small, and then sometimes, you can't help but have related people. So in subsection 2, there's some exceptions. A sheriff in the appointment of a person as a cook or an attendant. School district trustees, if all the trustees, with the exception of any trustee who is related to the person being appointed and who must abstain from voting for the appointment, approve the appointment of the person related to the trustee. A school district in the employment of a person as a substitute teacher who is not employed as a substitute teacher for more than 30 consecutive school days. The renewal of an employment contract of a person who was initially hired before the member of the board, bureau, or commission, or the department head to whom the person is related assume the duties of office. The employment of election judges. The employment of pages or temporary session staff by the legislature. Or county commissioners in a county with a population less than 10,000 if all the commissioners, with the exception of any commissioner who is related to the person being appointed, who must abstain from voting for the appointment, approve the appointment of the person related as a commissioner. Okay, so that statute's a handful in there with all the exceptions, but the main point is to just take a look if it applies. And so there are some other statutes that apply to appointments to office. That would be 2-2303 and 2-2304. Take a look at those, then you can brush up on, it may not be particularly relevant to legislative work, but it's always good to know. All right, so here we go. We got a hypothetical question, one more for you. This one's shorter than the last one. That was really long. You, in your capacity as a state senator, have decided that you're going to hire a temporary legislative aide for the 2015 session to assist you with respect to constituent services and legislative policy matters. You have had 2 people approach you about the legislative aide position. One individual is your uncle's son, who has no experience or aptitude for the position, and the other individual, who is not related to you, is clearly qualified for the position. The question: can you hire your uncle's son for the temporary legislative aide position during the legislative session. All right, I'm seeing some heads nodding. Yes, you're right. It was a trick question. Everyone, a trick question. I had gone over those exceptions, and one of the exceptions is temporary staff during the legislative session. So yes, you can hire your uncle's son with no qualifications and no aptitude for the position. All right. We have a bunch of other questions in there. Go through them, on your free time when you have them. Feel free to contact me anytime. Any questions on this? All right. Thank you.
He is that good. All right. Thank you. Okay, I'm going to wrap up my part with some flashy topics, bribery, official misconduct, and legislative immunity. So for bribery, it's an official, bribery is, I want to turn to page 7, I'm sorry, page 7 of the ethics quiz, and we're going to go over a hypothetical regarding bribery. This is hypothetical situation number 5, okay? So 2 days before the hearing on a bill that would benefit ABC Construction Company, you receive a call from the owner of that construction company who encourages you to approve the bill. The person informs you that it would be good for state jobs and you personally as well. As an added incentive, the caller also says that he would be sure to send you a portion of the profits from his company that are received as a result of your support of the bill. You inform the caller that you would be happy to vote for the bill and ask how much you should expect to receive. The next day, you vote to approve the bill, but so far, you haven't received any payment. So the question is can you be held criminally liable for agreeing to accept money in exchange for your vote on the bill? Yeah, I don't think I even need to read through any of these. It doesn't matter whether you received the money or not. It's the fact that you voted for it based on your understanding that you would receive money. So I think bribery is probably a gut. You just go with your gut. If there's a quid pro quo, then you would assume it's bribery. And it is a criminal violation. If you turn to page 8, I think it states it at the very bottom, that a person convicted of bribery may be imprisoned for up to 10 years or be fined up to $50,000 or both and is barred from holding public office in the state. So pretty significant. But given our history in Montana, one could see why we have such a stringent law. The next thing I want to address is official misconduct. This is also found in Title 45, which covers all of the crimes. It's a broad official misconduct statute, and it prohibits a public servant from doing such things as purposefully or negligently failing to perform any mandatory duty as required by law or a court, or knowingly performing an act that the person knows is forbidden by law. So you could look at this section, again, it's 45-7-401, the code on that, and I would just look at it for more information on what constitutes official misconduct. And again, there is a penalty. A person who is convicted of this offense will be fined up to $500 or imprisoned for up to 6 months. And if convicted, a public servant is also required to permanently forfeit their office. So let's turn to a lighter subject, and that's legislative immunity. That's one we all like. I wanted to touch briefly on the concept of legislative immunity through the use of a hypothetical. This is going to be our hypothetical number 9 on the quiz. That's page 11 for you. So legislative immunity is a constitutional form of immunity that protects legislators from being sued for certain actions and decisions that are taken within the course of serving as a legislator. Legislative immunity is based on Article 5, Section 8 of the Constitution, which provides in part that a legislator shall not be questioned in any other place for any speech or debate in the legislature. So let's look at hypo number 9. As a new legislator, and because you are somewhat unsure of the protocol, you decide to make a personal address during a floor session regarding individuals who had commented on a proposed bill. And these individuals who commented on the bill are from your district, and you know them quite well. So during a point of privilege, a personal privilege, you rise to address the body and proceed to name the individuals. And then you claim the individuals have been dishonest in their representations and point out examples of their dishonesty in your district. Later, you find out the individuals are very upset and they are contemplating filing suit against you. So the question is, can you be held civilly liable for your statements that are made on the floor? A, yes, because you personally named the individuals and it's possible the information was not true. B, yes, because legislators cannot discuss individuals by name during the legislative process. C, no, because legislators cannot be held liable for anything while they are elected officials. Haha. And D, no, because the Montana Constitution grants legislators immunity from suit with legislative acts, including speech or debate during the legislative process. So our answer here is D. I would just keep in mind, though, it doesn't give you, it's not a free pass, not a carte blanche, but the whole purpose behind it is so legislators are not concerned or bullied about what they might say, and they can have open and honest discussions to benefit our state government. So I think that's all I have, and now I'll pass it off to Jarrett. Thanks.
Thanks, Julie. We're getting close, so bear with us. There's a handout that's different than the two handouts you've been looking at. This one says provisions that govern the ethics committee process at the very top. It's on white paper. Should only be a couple pages. Just going to cover this really, really briefly so we can get you a little bit of break before the next presentation. So, provisions that govern the ethics process. The most important one is to always start out with the Constitution, and you'll see in your handout right at the beginning of page 1, there's Article 5, Section 10 of the Montana Constitution. This provision, when you get through the middle of it, says each house may expel or punish members for good cause shown with the concurrence of 2/3 of all of its members. So this is the constitutionally based provision that governs what the body may do when it comes to ethics regarding your own members. There's also a statutory provision, and that statutory provision is at the bottom of page 1, and it governs the ethics committees and the process on that. It's 2-2-135. In that it says each house of the legislature shall establish an ethics committee. I'll go through the rules, at least through the draft rules, and you can see where those are established. The committee must consist of 2 members of the majority party and 2 members of the minority party. So it's equal party membership. May meet jointly. Each committee shall educate members concerning the provisions of this part concerning legislators and may consider conflicts between public duty and private interests. So you're receiving the education as part of the statutory obligations right now. I work for the Legislative Services Division, which would include the Ethics Committee, and so you're getting your education right now on ethics with that statute. And then there's a provision in there that refers to the Constitution. In reviewing Mr. Everett's presentation of this 2 years ago, the co-commissioner, he reported that he's been here 27 years now, and during that time frame, he's only seen the ethics committee process triggered 1 time. So that's a good thing. It's not a common thing. But again, you need to have a little bit of knowledge about it just to go forward. So, and I guess that was in the 90s. It dealt with a legislator lobbyist issue with some potential intimidation by the lobbyist, and it was resolved through that process. So. Okay, so what would you do if you had an issue, an ethics issue? There is the ethics committee. You could do a formal route or you could do an informal route to try to figure out how to address this. The formal route would be to go to the chair of the ethics committee and ask the committee to take the matter under investigation. Obviously a fairly formal route. The informal route would be to talk to your leadership, and determine where to go from there. Or you could also talk to, of course, our office, the Legal Services Office downstairs, Legislative Services Division, and we could give you some information as well. On the second page, I did highlight the Senate rules that deal with the ethics process. You will see that the Senate, towards the bottom of the handout, actually has a Senate rule. And of course, the rules are still in process, but this is the most recent version of the rules. Senate 30-160 is a fairly involved rule that goes through the process, more so than the statute, and refers to referrals on that. I'm not going to cover that because you can see it in the materials, but there it is. And then if you flip the page, you'll see that the House really doesn't have any rules as far as like the Senate does, but there is the statute that governs the Ethics Committee. But of course, there still is a House Ethics Committee. You'll see in the House rules, which again, these are not the ones you've adopted yet as a body, but in 30-10 there is an on-call committee called Ethics, and that's at the very bottom. So if you have a House Ethics Committee as well, and again, good thing these have never been used much. So on that, I just wanted to see if anyone has any questions. That concludes this section, and we have questions open for the whole thing. And I had one more plug I had to give. There was a law school for legislators yesterday, and they were wondering if they filled out any of those valuations, they'd like to get them so they know what to give to you. Again, next session for law school for legislators. So we have that as well. If you have any to hand in, we can take those or whatever works for you. But if there's any questions, we can take them. If not, you're going to get about an 8-minute break before the code commissioner is here to give some rules training. Thank you. We really appreciate the opportunity to present in this great chamber. Welcome. Congratulations. You guys have a daunting task. And again, it's Jameson, Julie, and Jarrett. We thought we were selected because we all have a J name, but so you got the 3 J's this morning. Thank you.